This is Chapter 14, Test Review video. The police does not need a wiretap warrant before planting a person in a location so the person can record a suspect's conversations and then give those recordings to the police. Under eavesdropping and the misplaced reliance doctrine, that's true. The police does not need a wiretap warrant to plant a person and have them wearing wires and record a conversation and then give that conversation to the police. No warrant is required. Also, undercover officers that are wearing a body wire do not need a warrant either. And private citizens are allowed to take photographs of police making arrests out in public. There's no, the police cannot prohibit private citizens from taking photographs out in public. That's under the eavesdropping and the misplaced reliance doctrine. Trap and trace devices record conversations made on the phone. Let's see here, skip that. That's kind of a weird question. Installing a GPS tracking device on the outside of a car in order to determine where it has traveled without keeping it under visual surveillance violates the driver's reasonable expectation of privacy. That's true. That was found a violation. The U.S. Patriot Act did not replace the Wiretap Act of 1968. It just added some additional information for terrorism. Currently, officers can look through a person's cell phone if it's on their person when that person's being arrested. Now, I don't know if the Supreme Court's going to change that, but as of right now, with this textbook and any test questions, that currently is okay for an officer to review a person's cell phone, look at their text messages, and photographs if the cell phone's on that person while they're being arrested. So we're going to go with that for the textbook right now. Roving warrants can be issued under the Wiretap Act that are not restricted to one specific phone. That's true. A Wiretap Act warrant would need stronger probable cause than an ordinary search warrant. That is also true. A wiretap initiated under the emergency provisions of the Wiretap Act is retroactive if an electronic surveillance warrant is obtained within 48 hours. That's also true. The Foreign Intelligence Surveillance Act, or FISA, is the exclusive authority for intercepting telephone calls for foreign intelligence inside the United States. That's also true. And they can also authorize seizure of physical items. The President of the United States is not prohibited from authorizing surveillance, electronic surveillance. That's a really strange worded question. So the President is allowed to do electronic surveillance of foreign intelligence, but it has to get court approval. It's kind of a weird question. I'm not going to ask you a question on that. Police may have an informant wear a wire that transmits conversations without judicial approval. We already talked about that. That's true. An electronic surveillance warrant would be needed if there could be a violation of expectation of privacy. If that's the case, then a warrant would be needed. And for the police to get a warrant for a PIN register, there's certain criteria that they need to justify an ongoing criminal investigation, that the device belongs to is involved in criminal activity, things like that. The exclusionary rule that is part of the Wiretap Act of 1968 states that information obtained using wiretaps that were not obtained in compliance with this act is not admissible in any hearing, trial, or other proceeding. I'm not going to ask you a question on that, so that's just something to review. A search warrant would be needed to open stored email and text messages that were stored long term. So just a refresher on that. Police may covertly enter a residence to install equipment authorized by the Wiretap Act whenever there is a valid Wiretap Act warrant. They may do that. Sneak and peek. Conversations obtained while monitoring a Wiretap Act warrant are admissible in court for people named in the Wiretap Act warrant and conversations with people the officers had no reason to believe were involved in criminal activity when the warrant was obtained. The Foreign Intelligence Surveillance Act, FISA, of 1978, as amended by the U.S. Patriot Act, provides the framework for obtaining electronic surveillance warrants for the use of electronic surveillance inside the United States for foreign intelligence. The Foreign Intelligence Surveillance Act, FISA, defines United States persons as citizens of the U.S. and lawfully admitted permanent residents. An application for a Foreign Intelligence Act, FISA, electronic surveillance warrant must be certified by Assistant to the President for National Security Affairs. I'm not testing you on that. It's just a review. Under FISA, a warrant for a physical search, you can obtain documents. Let's see here: seizing documents, reproduction of documents, alternation of information can be obtained. Prior to service on a bank, a national security letter must include a statement by a federal investigator that information is sought for foreign counterintelligence purposes to get a national security letter. That is the end of Chapter 14 test review.